it is my privilege to welcome you to this fourth Shabtai Rosenne Memorial Lecture, and I do so on behalf of the organisers, the sponsors, and on behalf of the Rosenne family, two of whom have travelled from Israel to be with us today. Just 3 years ago, we held the first memorial lecture here at the Peace Palace, and I said at that time that we hoped that we would be able to organise a series of lectures on topics and at locations which were especially significant in Shabtai's working life. He always appreciated professional and academic excellence, so there could be no better way of commemorating him and his massive contribution to the development of international law and its practice than by inviting leading scholars and practitioners to deliver lectures in his memory. It's a matter of enormous satisfaction to all of us involved in the project that our hopes have been realised. Professor Malcolm Shaw launched our series here in The Hague. The second memorial lecture was delivered at the Hall of the Law Society in London by Dame Rosalind Higgins, and the third was delivered by Professor Bertrand Ramcharan at the United Nations Library in Geneva. All three lectures were received with great appreciation by their audiences, as well as by those who have subsequently read the texts. Shabtai's beloved wife, Esther, passed away on the very day of the Geneva lecture last year, and we remember her with great affection. She and Shabtai were married for 70 years, and she was definitely the love of his life. But he did have other loves as well. He loved his religion, he loved the state of Israel that he helped to establish and to consolidate as Jewish and democratic. He loved international law and the World Court, and he loved this great Hall of Justice, where he received the first Hague Prize for International Law just 10 years ago. Underpinning all of these loves was yet another. He loved the truth. In his work as a diplomat and as a lawyer, Shabtai was committed to the truth. He endorsed wholeheartedly the maxim of Rabbi Shimon ben Gamliel, which is recorded in the Mishnah tractate of Avot. Rabbi Shimon said that three things sustain the world: justice, truth, and peace. When The Hague began to call itself the City of Peace and Justice some years ago, Shabtai and I were both struck by the absence of the third component, and we even cornered one of the city fathers at a reception here in the Peace Palace to beg for the inclusion of truth in the city's moniker. We received a very sympathetic hearing, but were obviously overruled by the branding experts. Like Shabtai, Professor Tim McCormack has shown that he regards true facts as the indispensable basis of robust and effective legal systems and regimes, and he has already done sterling work to ensure this basis in several different contexts. Through his varied activities, he has made and continues to make a very notable contribution to the development and application of international humanitarian law. In a few moments, he will be introduced more formally by Jeroen Vervliet, the director of the Peace Palace Library. But having been in touch with Tim since his student days, I couldn't end my words of welcome without expressing my admiration for his achievements as an academic researcher and writer, as an inspiring teacher and lecturer, as a practitioner, and as a practical man of action. There could be no better illustration of this remarkable combination of qualities than the fact that during a recent sabbatical year, he not only constructed a peerless project on war crimes trials, but also constructed with his own hands what has been described as the finest garden shed in all of Tasmania. And you don't have to take my word for it. If you ask him nicely during the reception, he'll take out his iPhone and he'll show you photographs of the shed from all angles. That's right, yeah. Tim, thank you for talking to us today. Jeroen, over to you. But could I ask you all just to turn off your phones if you haven't already done so, and please remember that we're filming, so what else should not be done? No flash photography. Yeah, thank you.
Excellencies, President of the International Court of Justice, Ambassador Chaim Divon, of the Embassy of Israel. My name is Jeroen Vervliet. I'm Peace Palace Library Director, and it is my pleasure and honor to welcome you to this 4th Shabtai Rosenne Memorial Lecture. As a special Peace Palace Library Lecture, it is today a continuation of a cooperation with the Embassy of Israel. For we have jointly held a Adolf Eichmann trial evening and Judge Gabriel Bach lectured. By the way, it is broadcast on the Peace Palace Library website, as will the lecture of today be broadcast from tomorrow onwards. Within the topic of Eichmann, Shabtai Rosenne authored his 6 Million Accusers, Israel's Case Against Eichmann. Of course, in the Peace Palace Library collection. The bridge between the Israeli Embassy and the Peace Palace Library received an even more solid substantiation during the Peace Palace centenary in 2013, as the Israeli Embassy donated some important law books, and amidst those was Benivre Hamishpat Ben Leumi, Shabtai Rosenne's Hague Academy of International Law General Course, The Perplexities of Modern International Law. Published in 2001 in the Recueil de Cours, the collected courses by Martinus Nijhoff, nowadays an imprint of Brill, a publishing house with which the Peace Palace Library frequently cooperates. Brill is also one of the principal organizers of today's evening. Some of Rosenne's books in the Peace Palace Library are on a small table next to Brill's booth in the hall of the Peace Palace, and you can go through them after the lecture by Tim McCormack. I met Shabtai Rosenne only once and briefly, as he was attending the reading of the International Court of Justice view on the Iran-US oil platforms case in 2003. It was windy and cold, like today, and he wanted to quickly get into the Peace Palace, and I helped him through. Thereafter, we corresponded on the Dutch post-Second World War Mr. International Law, Professor Francois, and Francois' stand during the war itself. We are very appropriately in the Great Hall of Justice of the International Court of Justice today. Shabtai Rosenne was very much a The Hague man, as the majority of his books mirror themes like the International Court of Justice, the Permanent Court of Arbitration, and for instance even the 1899 and 1907 peace conferences. During the latter, the 1907 peace conference, neutrality was described in 2 conventions. It's now 2014, 100 years after the outbreak of the First World War. The Netherlands remained neutral. Next Tuesday, another kind of Peace Palace Library lecture will be held at 5:15 in the evening by Maartje Abbehuis, and it will be on neutrality. And I invite you to register for that. And please visit the exhibition at the opposite side of the hall, which is also on the First World War. Before passing on the microphone to Tim McCormack for the 4th Memorial Lecture, and after which we will have 15 minutes for questions and answer, it's my pleasure to give a brief overview of Tim McCormack's life in international law. Tim McCormack is a professor of law at the Melbourne Law School and an adjunct professor of law at the University of Tasmania Law School. He is an advisor, specifically on international humanitarian law, to the prosecutor of the International Criminal Court. He served also on the Turkel Commission. He was an amicus curiae of the International Criminal Tribunal for the former Yugoslavia in The Hague for the trial of Slobodan Milosevic. In the field of scholarly work, Tim McCormack is the co-editor-in-chief with Judge Christopher Greenwood of his English language series called International Humanitarian Law, published by Nijhoff, Brill, the publisher of the current Recueil de Cours collected courses of the Hague Academy of International Law. And he currently works on some history of law issue, being Australia's 300 war crimes trials of Japanese defendants in the period 1945-1951. It's now my pleasure to invite Tim McCormack to the rostrum.
President Tomka, other excellencies, judges of the International Court of Justice, the International Criminal Tribunal for the former Yugoslavia, the International Criminal Court, ambassadors, distinguished guests, ladies and gentlemen. I'm sure that covers everyone. There are no cousins of mine here tonight. It's a great honour for me to present the 4th Shabtai Rosenne Memorial Lecture. And I thank the Peace Palace Library and Jeroen. I thank the Embassy of Israel and Ambassador Devon, and also Nijhoff, Brill, and Alan Stevens and Lindy Melbourne for the honour that they've bestowed on me. It's hard to imagine a more appropriate venue than the Great Hall of Justice in the Peace Palace to honour the memory of Shabtai Rosenne, which of us international lawyers did not grow up reading him on the law and practice of the International Court of Justice. And I learnt tonight for the first time he was the inaugural recipient of the Hague International Law Prize in this very room. I met Shabtai Rosenne several times, but it was always in The Hague, never in Jerusalem. Always through Alan, actually. And so, again, it's appropriate for me, I think, to deliver this lecture in this city and in this venue. It was my great regret that I didn't have the opportunity to serve on the Turkel Commission with Shabtai because he had already died during phase 1 of the commission and I didn't join until phase 2. But I think it's very special that someone in their 10th decade, at 92 years of age, after such a long and distinguished career in public service, would die while still undertaking service on that commission. He was, of course, an obvious choice for the government of Israel to sit on the Turkel Commission when he was first invited to accept the appointment. But the person who spoke to him made a fundamental error of judgment, a sort of rookie mistake, when he suggested that it wasn't necessary that Shabtai know anything about the law of naval blockade. It was enough that he knew a lot about international law generally. Shabtai reminded this impertinent upstart of his 1946 British Yearbook of International Law article, which you'll see right on the last page of the bibliography of his publications, that he had published on precisely this topic, Modern Blockade, Some Legal Aspects. And time again, Shabtai apparently reminded not only this particular individual, but other members of the Commission about back in the 1940s or the 1950s or the 1960s when we looked at this issue. He was always drawing on past experiences to inform contemporary activities. Reflecting on the past because of how lessons could be learnt from it, but not dwelling in it, not a prisoner of it. The executive officer of the Turkel Commission told me that he visited Shabtai at his home in Jerusalem just after the establishment of the Turkel Commission. And Shabtai asked him why he hadn't told him about the petition that had been filed at the Supreme Court of Israel in relation to the Turkel Commission. And he showed Hoshea Gottlieb the particular petition online on his laptop computer. Hague was shocked. He had no idea about this petition, so he called the Ministry of Justice there and then, and no one at the Ministry of Justice knew about the petition either. Turns out the petition hadn't even been filed with the registry of the Supreme Court of Israel before it had been posted online, and Shabtai had already seen it before it had become an official document. He was on top of his game and well and truly engaged in modern technology, despite this wonderful memory of recalling lessons learnt from the 1940s and 50s and 60s and 70s. So, Shabtai passed on during phase one of the Turkel Commission, and at that stage there had been two international observers appointed to observe the proceedings of the Commission. One of them was Lord David Trimble, former First Minister of Northern Ireland and former recipient of the Nobel Peace Prize for his involvement in resolving the Northern Ireland conflict, and also Brigadier Ken Watkin, formerly the Judge Advocate General of the Canadian Armed Forces. Ken Watkin had had to retire from the Commission at the end of phase one to take up a visiting professorship at the US Naval War College in Newport, Rhode Island, and so he had to leave and go to the United States. I feel like I'm constantly following Brigadier Watkin because I replaced him for phase two of the Commission's work, and I also plan to head next year to Newport, Rhode Island to take up that same visiting position. But I've reflected a number of times on the naivety that I had when I first joined the Turkel Commission about the centrality of investigations. And here some of you will be relieved that finally I'm getting to the subject matter of the lecture. I'd always assumed, naively as I concede, that you have a violation of international humanitarian law, a war crime, and then you should have a prosecution. But of course there's a fundamental step in between, and that is the investigation. And as I reflect on my naivety, I'm surprised by it, because it's not as if I came to the Turkel Commission only from the academy, never having been involved in international criminal trials. Throughout the Milosevic trial, throughout my experience of the proceedings against the Australian David Hicks before the US military commission in Guantanamo Bay, or the international criminal court trials that I'm involved in, there are always fundamentally important investigations that underpin those trial proceedings. In the Australian military courts martials that I've been involved in providing advice about, the investigation is absolutely fundamental. So in this phase two of the Turkel Commission, phase one focused on Israel's investigation and response to the interdiction of the humanitarian flotilla heading to Gaza, trying to break the naval blockade. Phase two focused much more generally on how Israel investigates alleged violations of international humanitarian law. And I personally am very proud of the Phase 2 report, because I think it represents the first comprehensive and systematic analysis of the international law of national investigations. In the first chapter of that report, we talk about the what, why and how of international investigations, and really it's that first chapter I want to focus on most tonight. In the second chapter, we summarise a comparative study of 6 national military justice systems: the United States, the United Kingdom, Canada and Australia as 4 common law jurisdictions, which Israel also is, and Germany and the Netherlands by way of civil law contrast. And this report constitutes a constructive and positive Israeli contribution to international law, and I congratulate the State of Israel on having commissioned it. I don't speak tonight in my capacity as Special Advisor on International Humanitarian Law to the Prosecutor of the International Criminal Court. I need to make a disclaimer. I don't purport to represent the views of the Prosecutor or of her office. And here I acknowledge the Deputy Prosecutor, James Stewart, who may well be relieved to know that I'm saying that explicitly. When I was first approached by Hague Gottlieb to join the Turkel Commission for Phase 2 and to follow Brigadier Watkin as the second international observer, Lord Trimble continued right through both phases. I spoke then to the prosecutor of the International Criminal Court, Mr. Moreno Ocampo, and asked him whether he was happy for me to take up this role. And his reaction encouraged me. He said that states parties or non-states parties to the Rome Statute that want to take more seriously improving and evaluating their own national investigative processes should be encouraged by the International Criminal Court. This is consistent with Article 17 of the Rome Statute and the principle of complementarity, and he was very happy for me to be involved. I really appreciated that support from him, and I've had a great experience involved throughout Phase 2. So let me just try to give you an overview tonight of some of the key lessons, particularly out of the first chapter of the report. Why investigate, what to investigate, and how to undertake investigations. And then I'll make a few observations about some of the recommendations that were made to the Israeli government in the report. So first of all, why undertake a national investigation? What is the source of the international legal obligation to investigate allegations of war crimes? Those of you familiar with international humanitarian law will know Common Article 1 to all 4 Geneva Conventions, and expressed in precisely the same terms in Additional Protocol 1, the obligation to respect and to ensure respect for the Conventions and for the Protocol in the context of armed conflicts, and to criminalise serious violations of the law. The Geneva Conventions and Additional Protocol 1 also oblige states parties to facilitate compliance with the rules of the law through a range of different activities: dissemination and education of the entire population, appropriate military training, and the reporting obligations, as well as the undertaking of disciplinary measures. States parties to these 5 treaties are also obliged to search for and to bring to trial or to extradite to another country for trial those allegedly responsible for grave breaches of each of the 5 treaty regimes. None of those treaties include the word investigate. It's not there explicitly in any of those treaties. But the reality is that it's certainly there implicitly, because a state party cannot prosecute for grave breaches of any of those treaties without an effective investigation. The ICRC commentaries to the conventions and to the protocol, and also the ICRC's customary international humanitarian law study, are much more explicit about the obligation to investigate. And there are 2 other specific initiatives in those treaty regimes, specifically in Additional Protocol 1, about the military operationalisation of the rules of international humanitarian law. Article 82, for example, imposes an obligation on states parties to deploy military legal advisors in the context of military operations to ensure that military commanders are informed about their legal obligations. Articles 86 and 87 of Additional Protocol 1 also include a specific and very important duty on commanders. The commentary to Additional Protocol 1 talks about avoiding a fatal gap between legal obligations and effective implementation by ensuring that military commanders have a special duty to ensure that their subordinates are aware of the obligations that are owed, and to prevent or to punish those responsible for alleged violations of the law, or at least to hand them over to the appropriate authorities to deal with them. That's all in the context of international armed conflict, but even in non-international armed conflict, Common Article 3 and Additional Protocol 2 are silent on the question of enforcement, let alone on investigations. But we know that the interpretation and application of the ICTY statute, particularly first up by the Appeals Chamber in Tadic's challenge to jurisdiction of the tribunal over him, and then the ICTR statute in 1994, as well as the ICRC customary law study, all of them have confirmed the customary law criminalisation of serious violations of IHL in non-international armed conflict, and of the obligation on parties to a non-international armed conflict to investigate alleged war crimes. In the context of international human rights law, apart from the Convention Against Torture, none of the major international human rights law treaties impose an explicit obligation to investigate violations of each treaty regime. However, the obligation to investigate has been deduced from the general obligation to uphold and guarantee human rights, and also from the right to an effective remedy. The international human rights law, case law, and particularly that involving allegations of arbitrary deprivation of life, whether it's through the ICCPR or the European Convention on Human Rights, has been reaffirmed repeatedly in the case law, and I'll come back to some of those details in due course. But in the Human Rights Committee's General Comment number 31, in McCann in the UK and a number of other cases before the European Court of Human Rights, in the UN's Basic Principles on the Use of Force, and in the UN Principles on Effective Prevention and Investigation of Extralegal, Arbitrary and Summary Executions, over and over again, the obligation to investigate is reaffirmed. And thirdly, in terms of sources of legal obligation, in international criminal law, we're very familiar in this city of Article 17 and the complementarity formula for relationships between national jurisdictions and the International Criminal Court. We know that under the statute, under that provision of the Rome Statute, primary jurisdiction for investigation and for prosecution lies with states. The territorial state and the state of nationality both have a stronger claim to jurisdiction than the International Criminal Court. The ICC only has jurisdiction where both states are, in the terms of the statute, unwilling or genuinely unable to deal with the case themselves. Intriguingly, Article 17, paragraph 2 provides a number of examples of a lack of willingness by states. The third of those, Article 17.2c, talks about where the investigation or the prosecution proceedings were not or are not being conducted independently or impartially, and they were or are being conducted in a manner which in the circumstances is inconsistent with an intent to bring the person concerned to justice. The ICC has already had to deal with genuine inability to investigate or to prosecute in the matter of Saif Gaddafi, where the court and the Libyan government have had their own discussions about what inability actually means. We've also, in the context of the ICC, had to deal with unwillingness, in one situation at least, in the issuance of arrest warrants against Omar al-Bashir, Mohammed Haroun and Ali Khashab of Sudan, another non-state party to the Rome Statute. The ICC is yet to be faced with an investigation that the court deems not to be independent or impartial, or to be otherwise conducted in a manner which is inconsistent with the intent to bring the person concerned to justice. When that happens, if it happens, it'll be very interesting to see how the judges of the court determine what type of investigation is required. We know that Article 28 of the Rome Statute, in addition to Article 17, includes the alternative ground of individual criminal liability for military commanders and for political superiors, the superior/command responsibility provision that sits as an addition to Article 25 on grounds of criminal responsibility. A military commander or a political superior who fails to take all necessary and reasonable measures to prevent crimes by subordinates and to submit the matter to the competent authorities for investigation and prosecution can be held criminally accountable for that failure to act. This inclusion in the Rome Statute relates back to Articles 86 and 87 of Additional Protocol 1, at least in respect of military commanders. And in my view, the debate that rages sometimes about grounds of criminal responsibility focused on omission versus commission misses some of the importance of Articles 86 and 87 and this doctrine of command responsibility. There are some who argue that A ground of criminal responsibility based on a failure to act can never be as serious as a ground of criminal responsibility focused on physical perpetration or co-perpetration through another. But this particular rule in international humanitarian law, which is codified in Article 28 of the Rome Statute, is all about a person who has the authority to stop atrocities being perpetrated, failing to do that. And those who perpetrate atrocities, of course, can be held criminally responsible for the acts they commit, for acts of rape, for acts of pillage, for acts of murder of protected non-combatants or even wounded combatants. But this principle is about those who stand above their subordinates, who have the capacity and the authority to stop all of the atrocities going on, and who choose, for whatever reason, not to do that. Very important basis of criminal responsibility with direct relationship to this question of the legal obligation, or the source of the legal obligation, to undertake an effective investigation. Well, let me move to the second issue, what to investigate. What are the offences in particular that must be investigated? In international humanitarian law, we distinguish between serious violations or war crimes and other violations of international humanitarian law. Not all violations of the law constitute war crimes. Perhaps a good example is Article 36 of Additional Protocol 1, the obligation on states parties to undertake a legal review of any new or amended weapons system. We don't prosecute individuals who fail to implement Article 36, and of the 160 or 70 states parties to Additional Protocol 1, the ICRC has only identified less than 20 that actually implement this obligation. I'm not suggesting that that's okay, it doesn't matter. In this institution of all places, the failure to fulfil a treaty obligation has certain consequences, but it's not a war crime. The fact is there are other violations of the law which are considered serious. And here I'm not just talking about grave breaches of the Geneva Conventions and Additional Protocol 1. That's an obvious category of serious violations of international humanitarian law. But we know from the ICTY statute that Article 3, other serious violations of the laws and customs of war, or in the context of the Rome Statute, Article 8.2b, other serious violations of the law applicable in international armed conflict, and Article 8.2e, other serious violations of the law applicable in non-international armed conflict, are the other categories of serious violations. It's this body of serious violations of the law that from which the obligation to investigate derives. Let me make some observations then about how to investigate, or what are the standards for an effective or an acceptable national investigation. International humanitarian law tells us nothing about how investigations should be conducted. There is in the body of law some fundamental guarantees on the laying of charges and on fair trial rights, but not on the content of an acceptable, effective investigation. In contrast, international human rights law, and particularly the jurisprudence on interpretation and application of the relevant treaty obligations, provides a much more comprehensive and systematic guidance, and 4 key principles emerge from international human rights law: independence, impartiality, thoroughness, and promptness. Given the terms of Article 17.2c of the Rome Statute, why wouldn't judges of the International Criminal Court ask to assess the validity of a national investigative process turn to international human rights law jurisprudence to understand some of these terms? I'm talking here about the fact that Article 17.2c explicitly talks about independence and impartiality, as well as about the motivation of the particular national investigation. Let me deal with each of those principles in turn. First of all, independence. How independent is independent? Can the military ever investigate itself? There is, as we all know, no doubt, a problem of regimental inertia, of members of a unit trying to protect their colleagues. And some would argue, some NGOs, some individuals, some academics, would argue that the military should never be able to investigate itself. But the fact is that many states' military justice systems allow precisely that, the military to undertake its own investigations. The critical question is, what is the accepted level of independence? It's not just a question of state practice either, because Article 84 of Geneva Convention 3, for example, when we talk about the prosecution of a prisoner of war for an offence committed while in custody, actually envisages that the prisoner of war be tried consistently with the military justice system of the forces of the detaining power. International human rights law jurisprudence does not preclude state organs conducting investigations, but there are some critical elements to what independence really means here. One case that's helpful is McCormack against the United Kingdom. Talks about no hierarchical or institutional connection between those undertaking the investigation and those the subject of it. There must be clear independence between the investigators and those being investigated. In Ramsahai against the Netherlands, another European Court of Human Rights decision, it wasn't good enough in that case to have police officers in Amsterdam investigated by colleagues from their own district rather than from the State Criminal Investigation Division of the Netherlands Police. Investigations have to be undertaken by a body outside the military chain of command. Philip Alston, the then UN Special Rapporteur on summary, arbitrary and extrajudicial executions, in his 2008 report, identified three aspects of the independence requirement. First of all, formal independence. The structure of the investigative body must guarantee independence from any other arm of government, and that has to be reflected in the terms of mandate of the investigative body. But it's not enough to have formal independence reflected in the terms of mandate. It must also be practical independence. Even if formal independence is guaranteed, how is the body working in practice? Is the guaranteed independence translating into the practical work of the investigative body? And thirdly, there is a requirement, according to Professor Alston, of personal independence. Are each of the body's members independent with no vested interests in the outcome? Interesting three tests to apply. In relation to impartiality, this third test identified by Professor Alston, personal independence, flows into the question of what impartiality means. Here we're really focusing on the personal independence of individual investigators. Has to be no bias and no possible perception of bias on the part of any of the investigators towards any of those under investigation or otherwise connected to those under investigation. I had an interesting discussion with a friend of mine who's a judge in the Supreme Court of Victoria in my home jurisdiction in Melbourne. I was called to undertake jury duty, something that many of you from civil law jurisdictions won't understand perhaps, but in our common law tradition, 12 men and women of the public are appointed to juries to decide criminal cases as arbiters of fact in criminal cases. Now, I'd never been called to jury duty before, and I looked through all the categories for exclusion and none of them applied to me. So I turned up to the Supreme Court of Victoria to see whether I was needed for duty, but I'd had a conversation with my mate, the judge, and I said, what would happen if I got called before you? Would I recuse myself? He said, well, you wouldn't need to, I would for you. I would simply say, this person must stand down, because my obligation as an officer of the court is not to have any relationship with any of the members of the jury. Interesting example for me of what impartiality means. Even though he knew that I would make the same decision, whether it was him sitting as judge or someone else, it's about perceptions of bias. There's an interesting case decided by the European Court of Human Rights again, Gugliani, I'm sure that's a shocking pronunciation, against the state of Georgia, involving a high-profile murder case in Georgia, and the European Court was dissatisfied with the investigation undertaken because of evidence of a selective approach to the evidentiary material by Interior Ministry personnel and apparently unreasonable leniency towards the co-accused during both their detention and their trial. Question of impartiality, perception of bias as well as actual bias are fundamental to this aspect of an investigation. The third principle is thoroughness. An investigation must be undertaken professionally to arrive at an understanding of what occurred and who was responsible. In Geneva Convention 3, Article 121, for example, when a prisoner of war dies in custody, the detaining power must undertake a thorough examination to determine what happened and who was responsible. In Ristic and Yugoslavia, another European Court of Human... Sorry, not European Court of Human Rights this time, the UN Committee Against Torture found that an investigation into the alleged torture and death of the applicant's son was insufficiently thorough because of inconsistencies in evidence, inadequacies in forensic examination, and unsuitable expert witnesses. The European Court of Human Rights is less concerned with findings of guilt as they are with the markers of an investigation's thoroughness. Much more concerned they are with the process. Has an autopsy and necessary medical tests been undertaken? Has all relevant evidence been collected and documented? Have all relevant witnesses been identified and interviewed thoroughly and statements taken from each of them? Have conclusions been reached through a thorough analysis of all the relevant material? It's interesting that the European Court of Human Rights has not been keen to be prescriptive on measures to be undertaken. They accept that contexts and circumstances will vary. But the critical question has repeatedly been, has the investigation been undertaken thoroughly and professionally, and has evidence been secured early, effectively and appropriately? The fourth principle is promptness. An investigation should begin as soon as practically possible after the alleged incident, and unreasonable delay must be avoided. In the Rome Statute, Article 17.2b, the second example of what could constitute unwillingness on the part of a state, the statute talks about unjustified delay in proceedings, which is inconsistent with an intent to bring the person to justice. Time is a major factor affecting the ability to collect and preserve evidence. Crime scenes change, evidence disappears or degrades, memories fade, physical appearances change. I have to look at my wedding photos to know that. Witnesses might collude with each other or be threatened or bribed to alter their accounts. Timely investigations can also contribute to the perception that the law is being enforced and that justice is being done, and that only can generate public confidence in the law, which is an important supplementary benefit. We think about these four principles of what constitutes an effective investigation in the context of international human rights law, and then think about the context of an armed conflict. Interestingly, the UN Human Rights Council's International Independent Fact-Finding Mission report, the so-called Tomaschat report, named for Christian Tomaschat, the chair of the committee, they identified that the gap between expansive standards under international human rights law and the less defined standards for investigations under international humanitarian law is not so significant. But nonetheless, there are constraints during armed conflict that do impede investigations. In Alskaney in the United Kingdom, a European Court of Human Rights decision, the court talked about where the death to be investigated occurs in circumstances of generalised violence, armed conflict or insurgency. Obstacles may be placed in the way of an investigation. In the context of an armed conflict, It might not be possible to recover a body for an autopsy, for example. It might not be possible to secure a crime scene, to undertake the sort of thorough forensic investigation that we would expect in a normal law enforcement context. So there might have to be some concessions about what those principles mean, but there's widespread agreement, including by the Turkel Commission in the Phase 2 report, that those principles should be followed to the fullest extent possible. What to make of all of this in terms of the content of an effective national investigation? With all the scrutiny of Israeli military operations in Gaza and in the West Bank, I think it's unusual for the State of Israel to be seen to be making such a comprehensive and constructive contribution to the development of international law. That's a positive amidst some not so positive scrutiny, and I congratulate the State of Israel on the report. I think the endorsements of the Turkel Commission report multilaterally have been particularly interesting. Ben Emerson, for example, the UN Special Rapporteur on promotion and protection of human rights and fundamental freedoms while countering terrorism, in both his 2013 and 2014 reports, has drawn on recommendations from the Turkel Commission to argue the case for increased and stronger, more effective national investigations. Christoph Haynes, the UN Special Rapporteur on extrajudicial, summary and arbitrary executions, in his 2013 report, also referred to the Turkel Commission to substantiate a particular argument he wanted to make about stronger national investigations. But of course, a comprehensive report which is unimplemented is only a comprehensive report. The UN Secretary-General's report on Israeli practices discusses the Turkel report and urges Israel to implement its recommendations. The UN High Commissioner for Human Rights has also urged Israel to implement the Turkel report's recommendations. And those sorts of responses from the Secretary-General and the High Commissioner for Human Rights are entirely understandable. A state that engages in an investigative process and then receives a series of recommendations ought to take those recommendations seriously. Well, the State of Israel set up its own implementation committee, and the most important recommendation that's already been adopted is the establishment of a fact-finding assessment mechanism. The fact-finding assessment mechanism is outside the chain of command and is headed by a 2-star Israeli Defence Force general and has a number of investigative teams. Each team has operational expertise in relation to artillery, aerial operations, investigative skills and legal advice. And the FFA, the fact-finding assessment teams, have been investigating a number of operational incidents arising out of the recent incursion into Gaza and either recommend criminal investigation or close cases where, in the view of the fact-finding assessment team, there is insufficient evidence to proceed to criminal investigation. The Israeli Defence Force Military Advocate General has been publishing results of those cases which have been closed and has promised to publish results of criminal investigations when they're completed. The fact-finding assessment teams have compulsory powers, and it's now an offence under Israeli law to withhold information from them. This initiative is in stark contrast to the way things used to be done. Previously, we had in the Israeli Defence Force system what were called operational debriefs, which were the fact-finding process conducted within the unit structure of the IDF. It's one of the key recommendations of the Turkel Commission that does not represent an independent and impartial process. And so there's been a response to that. These fact-finding assessment teams have been much more prompt in undertaking their fact-finding assessments and making their recommendations to the Military Advocate General than ever occurred in the past, including in response to Operation Cast Lead in Gaza in 2009. So far, according to the Military Advocate General's website, 44 incidents are under consideration by fact-finding assessment teams, and 50 others have been identified which will be passed on to the fact-finding assessment teams in due course. 12 of the 44 have gone back to the Military Advocate General, and 5 criminal investigations have opened. You can have a great process, you can have a great report, it needs to be implemented, you can implement it and set up a great process, but still the process requires resources and experienced and professional personnel. So whether or not the fact-finding assessment, which represents a significant structural change in the way Israel undertakes national investigations, would hypothetically satisfy Article 17.2c tests remains to be seen. But from my perspective, the mere fact that not only Israel, but other states as well are taking more seriously the need to ensure that their national investigations are more effective or stronger than they've been before, even if the motivation for that is to avoid International Criminal Court scrutiny, whether that's present or whether it's in the future, possibly, hypothetically. And there's certainly growing anecdotal evidence of that. Then the International Criminal Court, by its very existence, or the Rome Statute by the terms of it, have already had a positive contribution in this particular area. Thanks very much for listening so attentively. I look forward to some questions and answers.
I was wondering if you had any ideas or thoughts about obligations on non-state groups, like rebel groups, to investigate, what obligations they have and whether the standard is similar to a state standard or different.
Yeah, it's a great question. And I think we're struggling to work it out, aren't we, as an international community, to what extent we would impose or expect non-state armed groups to live up to the same standards as states. But it's interesting that already in the context of the obligation on command responsibility to prevent atrocities occurring, or if they've already occurred, to take all necessary and reasonable measures to deal with those responsible and to hand them to the competent authorities. We've been trying to work out what or who are the competent authorities for a non-state armed group. Of course, there are all sorts of different types of non-state armed groups, and some of them may exercise quasi-state-like functions in effective administrative control over physical territory and already have some sort of justice system, however rudimentary, in operation. And maybe in those circumstances we can expect a higher standard of those non-state armed groups that have that sort of administrative role to play over territory, more than we can expect a non-state armed group that exercises no physical control over territory. And I'm not really sure, as an international humanitarian lawyer, how we are to evaluate the standards to apply to non-state armed groups in relation to that sort of obligation or the investigative one. I think that a decision-making body that is confronted with a factual situation that involves assessing what the non-state armed group has done or what they're capable of doing and the extent to which we would hold individuals criminally accountable for failing to meet a particular standard will be a challenging decision to make. And that doesn't help answer the question at all, and I'm conscious of that, but yeah, I think it's a tricky one for us. But thanks for asking it.
I'm Dan Saxon, and I teach international law at Leiden University College. In the 4 principles that you discussed about proper investigations, one thing that you didn't mention was the protection of the due process rights and fairness to the persons who may or may not be targets of an investigation, whether it's by an international court, a commission of inquiry. And I'm wondering how you see those obligations, if any, how they would fit into this puzzle.
I've had some discussions with the Australian Defence Force Director of Military Prosecutions about this very issue, because in the context of a number of incidents that have occurred in Afghanistan, for example, with Australian forces, there's been a question about the extent to which the Australian Defence Force Investigative Service, which replaced a military police service, taking the authority for the initiation of an investigation out of the military chain of command and setting up an independent investigative service. The question about the extent to which they can compel individuals, the subject of an investigation, to talk, and where the boundary or the demarcation is between eliciting information for the purposes of the investigation and the possibility of self-incrimination. So I understand that that's a challenging thing that has to be considered, and I think that a number of militaries are trying to grapple with that. There's been a push, certainly in Western militaries, to be more, to strengthen and to be more independent in terms of the structure of the military justice process. And one of the challenges that has been experienced by a number of militaries that have been undertaking reforms in relation to military justice is how we guarantee the fundamental guarantees, the fundamental rights of individuals who may become the subject of criminal investigations. So yeah, I understand that's a real issue and certainly has to be taken into account, and an international body like the International Criminal Court assessing the effectiveness of a national investigation would have to take that concern into account in its determination of whether or not those principles have been satisfied.
Thank you for your excellent talk, but I do have one question. When would you say that this international obligation to investigate becomes triggered? And by whom do the war crimes have to be alleged? Is it first triggered when the ICC issues an arrest warrant, for example, or is it when the international community begins voicing its concerns? And what happens if the state doesn't agree with these alleged war crimes?
Sure. Thanks, Olivia. The obligation is certainly not triggered by the ICC or by the international community. The obligation is inherent in the international humanitarian law and international human rights obligations that apply. So I guess it depends on the specific context in which the suspicions are aroused as to a violation of the law. If it's an armed conflict, then the international humanitarian law obligations will be the principal ones that apply. If it's in the context of law enforcement and perhaps riot control or other circumstances, then the international human rights law obligations might be the primary source of obligation. But either way, the obligation is on the parties to the situation. And in terms of the Turkel Commission's consideration of the international legal obligation, we talked about a slightly different trigger in either armed conflict or law enforcement contexts. So in law enforcement contexts where international human rights law is the prevailing body of applicable law, the trigger is a lower threshold one. Any death of a civilian triggers an investigation or the obligation to investigate. In armed conflict, where it's not automatically the case that the death of an individual is a violation of the law, or not necessarily, then the suspicion of a violation is at a higher, which triggers an investigation, is a higher threshold requirement. So there's a lot of discussion in the Turkel Commission Chapter 1 and also in some of the other documents I've referred to about the need for a fact-finding assessment which is independent of the chain of command that can help try to determine what happened and whether there is reasonable grounds for believing that a criminal investigation is required. And a number of militaries, in terms of the comparative study of the Turkel Commission, we saw that a number of militaries have an independent fact-finding mechanism. And the fact that the Israeli Defence Force didn't was one of the reasons why this was a major recommendation of the report. So, yes, I mean, it's not a question of the international community triggering the obligation. The legal obligations are there. And a state that waits until the international community puts pressure on it runs very serious risk of its own violations of its obligation or its obligations.
Professor McCormack, hi. My name is Jamie and I work for SFR. My question is regarding the obligation to investigate whether such obligation will be satisfied when the national authority decides to close the complaint on the basis of a preliminary examination rather than a full investigation. And what I'm thinking of in my mind is something similar to the OTP investigation or preliminary examination before it decides to open investigation.
Sure. I think the answer to the question is, well, it depends on the factual situation. And under Article 17.2c of the Rome Statute, we think about the example of unwillingness referred to in the statute. If there's a bona fide, independent and impartial inquiry which results in a conclusion that there is an insufficient basis to go to a criminal investigation, then I don't think an institution like the International Criminal Court is going to challenge that if it's satisfied of the bona fides of it. In Article 17.2c and the other examples of a lack of willingness put a major emphasis on whether there's an intent, a motivation to try to shield those responsible for criminal accountability. If what's going on is a sham, a malafide process, then it doesn't matter whether it's a preliminary inquiry or a full criminal investigation or even a trial process. If it's a sham, then it should be exposed as that, and the ICC will be able to declare that in this particular circumstance, this state is unwilling to deal genuinely with the individuals who are responsible. But the reverse is not automatically the case, that if it stops at a much earlier stage, that means it's a malafide process. That's not true. And the question will really be, on what basis was that decision reached?
Thank you for your wonderful talk, and perhaps I may tease you a little bit because you've been talking about investigation once there is already a presumption of a crime having been committed. Now I'd like you to tease you a bit because in my experience as a teacher of law and ethics at the military academy, it's also highly influential if the officers concerned know that a national investigatory mechanism not only investigates once there is, let's say, a bad report about a possible incident, but if they also are aware of the possibility that a national investigatory mechanism may investigate preemptively, let's say by sampling, even if there is no presumption of a crime having been done. The case of the use of air power by Western nations would be a case in point, because the usage of air power is a highly complicated affair. It involves a combined air operations center, it involves an F-16 or an F-18 pilot, and forward air controller, and so on. The whole procedure is very complicated, and would it, in your opinion, be useful if military officers would be aware of the fact that a national investigatory mechanism can also, by means of sampling, preemptively check whether rules and procedures have been followed correctly, even if in that particular incident no crime has been taken place?
But that's a very interesting question. I think I'd draw a distinction between what is the legal obligation and what might be strategically beneficial. And the reality is that in the commentaries, especially to Additional Protocol 1, the ICRC places a big emphasis on proaction, on the need to train militaries effectively, on the need for states to ensure that their military commanders at all sort of levels of the chain of command understand that they have an obligation to ensure that their subordinates know what their legal obligations are, and that if there is a violation of the law, then consequences will flow. I think in the context of my own experience with the Australian Defence Force, our preemption initiatives would come in training exercises where built into the military exercise there are some scenarios that trigger investigations. It's a way of sort of letting everybody know that this mechanism exists, and when it comes to the real deal of military operations, you need to understand that the mechanism is there, or that officers are expected to implement their obligations. I've never really thought about the precise scenario that you've raised, but I mean, I'm sure that a military that really wants to take seriously compliance with the law would find that suggestion very useful, and I might even raise it with the one that I work most closely with when I get back home. Thanks very much, Ted.
Thank you very much, Tim McCormack, and I think we can give him a big hand. And I now invite His Excellency Ambassador Hem Divon to the lectern for some closing remarks.
Very short. First of all, I'm so glad that there's no exam to follow but a glass of wine, so that's but very, very interesting. What an honor to commemorate the legacy of Professor Rosenne, legacy of your father-in-law. Here in the Peace Palace, in this very, very special room, exactly 10 years ago. And I would like to thank the team that made it happen, because it's a lot of work, and I think to keep this tradition is so important. First and foremost, Mr. Van Vliet, well, you've always been so terrific. And Mr. Alan Stevens, Miss Lindsay Mailman, she's somewhere here, I know. Yes, over there, of course. And Shoshi Reshef Moore from the embassy. And of course, Professor McCormack. That was very exciting, very interesting. So much for us to absorb, to analyze, to think of, because this is not just theory, this is practical approaches to current events. And therefore we are taking note very seriously of everything that you have shared with us. Thank you so much. And on a lighter note, I would like to invite all of you to raise a glass to enjoy a good glass of Israeli wine. Thank you very much for being here. Thanks.